Hello friends, welcome back to series of lecture. This is the fifth lecture of this series of Indian Evidence Act, and we are continuing with the topic relevant facts. So in the previous lecture we have left that there are certain facts which are related to a case, and out of these facts there are certain fact in issue, that is the main facts which have to be decided. But other than if there is no direct evidence like uh, eyewitness or videography, then the case is go on to prove with some other facts. So along with the fact in issue, there are some other facts also be in the case. These other facts are called the relevant facts, and since these are considered to be the evidences to together go on to prove the fact in issue. Together go on to prove the fact in issue. So these evidentiary facts or the circumstantial evidences are come in the other facts. So let's see this with an example of a case. So as we know that the relevant facts are the always the evidences of the fact in issue. इनके evidences होंगे, इसीलिए ये evidentiary fact और circumstantial evidences कही जाती है. Note down the case संतोष कुमार सिंह versus state through CBI, that is 2010 Supreme Court. In this case, the Santosh Kumar Singh was the son of ACP. So Santosh Kumar Singh was the son of ACP, Assistant Commissioner of Police. Santosh Kumar, Commissioner of Police का बेटा था. So at the time of this case, he was ACP incident. Later on, he became the DCP. Otherwise, अगर in daily nature, the Santosh Kumar Singh is very sober person. He was a tall, handsome guy, and he used to carry a bullet. And this man Santosh Kumar Singh is very introvert kind of person. But he was in relationship with a girl. So this is what I am telling you. This is not in the case introvert or sober all that, because this case is related to faculty of Delhi. अब इस केस के फैक्ट क्या थे? That there was a girl in the faculty who was junior to him. 1 or 2 years she was junior to him, and he was after her. He always follow her on his motorbike, etc. And the girl was 2 years junior, I think. So his LLB was over, and he joined the ILI, that Indian Law Institute. You cannot place Kasturba Gandhi Marg mein. So he has to have his classes in the evening there. But in the whole daytime, he was spending his daytime in the faculty, Delhi campus. And he will be always following her. Wherever she goes, he was watching her. And at several times, he stop her, and tried to talk to her, and she will oppose that. So that is what the case is. Now this man several times followed her, and the girl used to stay at Vasant Kunj, and she was followed by him up to her house. But at the times there was quarrel also. She will call police also. She will file complaint also. She has filed several complaints against him over a period of time. And since his father was ACP, so the complaint normally will directly file before the Commissioner of Police, and the Commissioner of Police at the times make them sit together and tried them to reconciliation, and promises was made by the Santosh Singh that I will not chase her, etc., etc. But one fine day it was found. अब story सुनिएगा, the main story. One fine day the girl left her home for the college, and at that day her father and mother has some work at the Tis Hazari Court, Delhi, and she used to stay at the Vasant Kunj. So in the car she came to the faculty, and her parents also came with her. And one more thing, by that time, the police also provided her a bodyguard. She belongs to a good family, plus at times Santosh Singh become regress at times. So the police had provided the bodyguard. So she used to travel with the bodyguard. So on that day they came. She dropped at the Tisajari court, and from there she came to the faculty. And when she came to the faculty, Santosh Singh was sitting on his bike with his helmet, and the helmet was kept on the motorbike. And at that time helmet was having the visor. Visor आप समझते हो, शीशा जो हेलमेट के सामने होता है, तो वो शीशा उस टाइम हेलमेट पे था. And that was a very important piece of evidence. The staff of the law faculty gave the testimony that visor was there. The bodyguard also gave the testimony that the visor was there. Now this girl went to the faculty, and on that date the bodyguard not come with her because he was late. So she directly called her directly to the faculty, and she drove herself the car on that day. Then on that date bodyguard उसके आने के थोड़ी देर बाद आया. So on that day, after the class get over, Santosh Singh followed her, and the bodyguard saw him to follow her. Bodyguard saw her being followed in the car, and the parents told that you go home, we will come later. Parents उसके साथ घर नहीं गए, and it was she and bodyguard who were going, and Santosh Singh was following her, but after a while he was disappeared. अब उसके आगे का स्टोरी है that she went to home, and there in the house she is having a small dog and a servant also. So after reaching the home, she said to servant to take away the dog far away for bask, because I am not feeling well, I want to sleep. So go away so that I will not get up in between. So she sent the dog and the bodyguard, and dog and servant, and bodyguard also. For bodyguard she also said that I do not need you right now, so you come around 5 o'clock. So the bodyguard also go went away. And since parents are in the Tisajari court, so they have to come into the evening. Now she went inside the home and locked the door from inside and went to the sleep or whatever. Now Santosh Singh was seen by one of the neighbors near the house after this. And since he used to visit always, so the neighbor recognized him that he is the one who chased her. So one of the neighbors gave the testimony that Santosh Singh was found there. And in the evening, around 5 o'clock, when this bodyguard came, he came with another constable because the police station is nearby. वो आपस में बात करते हुए पहुंचे. Then he rang the bell, but the door not opened despite persistent pressing the bell. So they went to the back side of the house, and the back door was open. They went inside and they found in the bedroom that Priyadarshini Vattu, that girl, was lying on the ground near the bed. तो बेड था उसके, मतलब बेड के थोड़ा सा अंदर और थोड़ा बाहर की तरफ, कुछ पार्ट बेड के अंदर और कुछ बाहर. And there was plastic glass pieces was scattered on the floor, and a heater wire was found surrounding her neck, and the t-shirt of the girl was torn from one side, and otherwise she was well dressed. She has the undergarments on, plus she was wearing a jeans and t-shirt, and the t-shirt was torn, that girl's suit. So t-shirt फटी हुई थी, and it was blood. Now the postmortem report came, and it suggests that she was killed by strangulation. Plus, it, her lot of ribs were broken by hitting some heavy object. at the back of head and shoulder particular, from the back and from the front also. Strangulation is due to the heater wire, and ribs broken by heavy object. That could be a helmet, bullet helmet, क्योंकि जो blood का helmet होता है, that is very heavy come with it, and the pieces of visor was found all of there, and it was also proved that she was raped. अब it was a mystery that how after the rape and murder she could wear the entire dress, undergarments, the jeans and t-shirts also, and then she died. So that was not focused much into the case. कुछ कुछ लूप होल्स हैं इस केस में. So ये अभी तक मिस्ट्री बनी हुई है कि आफ्टर द रेप एंड मर्डर उसने पूरी ड्रेस अंडरगारमेंट्स को भी और पूरी ड्रेस को इस तरीके से पहना जैसे एक नॉर्मल व्यक्ति पहनता है, नॉर्मल लड़की पहनती है व्हेन शी वाज अलाइव. बट दैट इज नॉट फोकस्ड इनटू द केस. अब केस में जो लॉयर कलेक्ट करेगा फैक्ट्स, उसी पे तो केस डिसाइड होगा. प्लस इस केस में घर के अंदर एंट्री कैसे हुआ उस पर भी क्वेश्चन मार्क है. अब वो डोर अंदर से कैसे ओपन हुआ, या तो उसके पास की थी या फिर शी हरसेल्फ ओपन द डोर. So this point also was not properly covered in the case, and these two are very important facts. If one had come to murder her and rape her, तो rape की अगर हम बात करें तो rape तो under fear one can do. Putting gun over her head, the one can always commit rape, and she may submit. But उसमें भी जो private parts थे उस पर injury marks नहीं थे. And the girl of her age, obviously when the rape was committed, obviously she was resist, and she was immensely resist unless उसको कुछ बेहोश वगैरह ना किया गया हो, but that was not came into the postmortem, or some fear was not there. और इस केस में possible है कि that she was put into fear and she was submitted, but maybe it be possible कि that rape was committed after that, after committing of rape, she was properly dressed up like no sexual offense was committed, and then after that she was hit because she was hit upon the t-shirt. Means that after committing of the rape she dressed up, and after that the fight was, or the incident of beating was occurred. Then from another angle it may be possible that a person came and murder the girl, and after that he committed the murder, but he will not be the person who would do this act, he would not be bothered about the wedding dressing up and all that. So there is loophole in the case, but again not commenting upon much upon that. And in this case the court held that the fact in matter that he has came into the house, because the evidences suggest that he was the one who committed the murder. How he came into the house, that is not important, but the fact is that it is him who has committed the murder, and the DNA sampling was matched, so it is him who has committed the rape also. So the other evidences are so strong that the fact that how he came inside the house as can be ignored. Maybe he is having some master key, or maybe she opened the door herself under the appeasement that I want to reconcile with you, or maybe she called him. So many things are possible, and that is all are quite logical also. Because why she sent the servant and dog also, why she sent the bodyguard also, why she want to have that private time, personal time till 5 o'clock. So there are various other possibilities, but in this case the evidences are so strong कि इन छोटी छोटी बातों को कोर्ट ने इग्नोर किया है, because other evidences are very strong. In the DNA test the semen sample has matched, and therefore you are the one who has committed the rape. Then he was in the faculty, and in morning she was in the faculty, and before that she was in the home at night. So before the incident, sexual intercourse cannot be happened, not possible to happen, and the sexual intercourse can only happen after she came to home after 3 o'clock, and after that the 3 o'clock the sexual course has happened, and within that period the death was held. And it is the visor of your helmet and with other facts it was found there in the house. Then आगे क्या होता है इस केस में? The dead body was found, the mother and father was called. Now the mother and father came and declared that it is Santosh Singh who did this because he is after her daughter, their daughter. Then the bodyguard also told to the police officer that I see him chasing. And then the neighbor also came and said that around 3:30 I find him roaming around his house, her house. So the suspicion went upon him, and around 6 o'clock or later than that, he was arrested from ILI, from the Indian Law Institute, and there later on in the case the peon of the ILI has given the evidence that on that day he came late. 6 o'clock was the 6 o'clock was the starting time of the class, and he came later than that, about whatever 20-30 minutes, and he was insisting and threatening him that enter his time of entry to 6 o'clock. क्योंकि वहां पे अटेंडेंस होता है टाइम के साथ, उसने काफी कोशिश की, डराया धमकाया, तो पियोन को डराया धमकाया, फिर भी पियोन ने वो 6 बजे की एंट्री नहीं की। तो उसमें शायद रजिस्टर में अराइविंग टाइम 6:15 या 20 का है। प्लस उसको जब पकड़ा गया तो उसके पास हेलमेट था, पर हेलमेट में निशान थे चोट के, हेलमेट पिचका हुआ था कई जगह से, प्लस हेलमेट में वाइजर नहीं था, प्लस उसके जो रिस्ट थी हाथ की, एक हाथ की रिस्ट पर, एंकल पर, देयर वाज माइल्ड फ्रैक्चर एंड wounds, and that was bandaged. And on asking about that fracture or wounds and helmet, he said that I was fell from my bike and my hand was fractured and helmet was broke. And when the medical exam was done of him, the doctor finds that the injuries are the very fresh injury. So doctors ने injury को fresh बताया, और marks of जो marks on the helmet जो थे, that was not of that kind के रोड पे एक्सीडेंट हुआ है, क्योंकि रोड पे एक्सीडेंट होगा तो वो स्क्रैच करेगा, स्क्रैचेस होंगे उस पर, और उसका कलर नहीं गया था। एट सम प्लेसेस थोड़ा सा पिचका हुआ था स्पॉट वगैरह, but not scratches on that. Means it was hit on some soft object. It was hit on some that object which does not cause scratches. So these are the facts in this case. अब उसके बाद these undergarments were collected, the semen sample was collected, and the DNA testing was done. और DNA testing में it was a perfect match. But in the trial court, what happened was that he was the student of the law faculty. So lot of hue and cry was raised by his friends, who was also the ex-law faculty students and who was in just in practice. तो ऐसे काफ़ी स्टूडेंट थे जो लॉ पास आउट थे और प्रैक्टिस स्टार्ट की थी। as as I said that he otherwise was a very good human being, so उसके बहुत सारे काफ़ी अच्छे दोस्त थे. He is having a good circle. So there was very hue and cry, and in the court, नारेबाजी वगैरह all those things was there. अब इस केस में एक नया मोड़ आता है, जो डीएनए सैम्पलिंग का जो पैकेट गया था आफ्टर सीलिंग इट, द सील ऑफ दैट बॉक्स वाज फाउंड ओपन. जिस डब्बे में उसका अंडरगारमेंट रखा हुआ था वो सील टूटा हुआ था. द ट्रायल कोर्ट टुक दिस टू बी अ ग्राउंड and held that the DNA sampling cannot be relied upon because the seal of the packet was broken, and therefore we cannot rely upon the evidence. And this evidence of rape is not reliable, and the rest of evidence is circumstantial evidence is not sufficient to prove for the guilt of murder, and therefore he was acquitted from the trial. And later on, this man was settled in life, have children, and he started good practicing in the court. But somehow, an appeal was filed much later. I think after 6 7 years, appeal was there in the High Court, and the High Court opened the case again. And again, the case was brought up before the High Court, and the High Court set aside the judgment of the trial court and convicted him and gave him the death sentence. On the same pieces of the evidences, it relied upon the DNA testing and held that the mere fact that the packet was opened, that does not mean that the semen found on the undergarment was not yours, and the court relied upon that and other circumstantial evidences, and the death sentence was pronounced. Then he makes the appeal to the Supreme Court, and in the Supreme Court upheld the conviction but converts it into the life imprisonment. So final status जो 2010 में सुप्रीम कोर्ट का जजमेंट आया था, that was converted into the life imprisonment. So this is the case. अब इस पूरी स्टोरी में आप फैक्ट सोचिए, मेन फैक्ट क्या है. अब इसमें फैक्ट इन इशू क्या है, वेदर ही किल्ड. अब इंटेंशन भी देखेंगे बट उसके बाद में आएगा वो क्वेश्चन. फर्स्ट वन इज वेदर ही कॉज द डेथ, देन वेदर ही कमिटेड द रेप. सो द फैक्ट इन इशू इज the causation of the death and the causation of rape. Now, in this case, you do not have any eyewitness of the case. Priyadarshini Mattu was dead. There was no CCTV in the house. You do not have any video recording. You cannot have any kind of direct evidence. So, in order to convict him, you have to rely upon the surrounding circumstantial evidences, or which is called the relevant facts. Now you see what are the facts in this case. There are several facts like past conduct. Past conduct क्या था accused का? Quarrels between the victim and accused. Complaint by the victim girl. Then the other conduct of chasing her on the day of the incident. Then what? Pieces of visor, helmet, broken glasses, fallen on the spot, then fracture on the wrist, and then very importantly he spoke a lie about the fracture. जो फ्रैक्चर हुआ था उसके बारे में और हेलमेट के निशान के बारे में उसने झूठ बोला था. देन DNA, उसके बाद कॉलेज में जो लेट एंट्री, देन थ्रेटनिंग द गार्ड, देन हिज प्रेजेंस ऑन द स्पॉट, टेस्टिमनी ऑफ द नेबर. So here we are talking about only those facts which are in his disfavor, the things which are against him. And ये जो भी हैं ये facts हैं, ये evidences नहीं है, और हर एक fact किसी न किसी evidence से proof होगा. जैसे यहाँ पे presence on spot, he was present on the spot. So इसका जो evidence दिया गया है that is by the neighbor. अब similarly visor was there on the helmet. अब visor के pieces were found on the spot. So the testimony of the canteen वाला that there was visor on his helmet. Plus bodyguard ने बयान दिया कि visor था. Parking वाले ने बयान दिया कि visor था. So by this they established the fact the helmet has the visor. So what are these? These are witnesses. They are giving the evidences of the fact that visor was there on the helmet. Plus जब घटना हुई और घटना के बाद जब the police team came, they prepared an inspection and memo, seizure memo. जब कहीं पर कोई घटना होती है तो वहाँ पर जो जो चीज़ें पाई गई होती हैं सबको आप सीज करते हो और सीज करके रखते हो, और वहाँ पे उस लोकेलिटी में विटनेसेस को बुलाते हो और उनको साइन करवाते हो. दैट इज व्हाट कॉल्ड द सीजर मेमो. नक्शा बनेगा वहाँ पर how the dead body was found. So these are all very important documents later on. And with the help of the witnesses and the Caesar memo and the witnesses who had signed the Caesar memo, it was proved that the pieces of visor was found there. Then number two, with the help of the canteen wala, bodyguard, etc., it was proved that in the morning the visor was there on the helmet. And there when he was arrested, at that time also the helmet was seized. And when the helmet was seized from him, there were two witnesses of ILI who had signed the Caesar memo there, and they had written there clearly that the helmet has not visor. Plus, there was marks on the helmet of some soft object, as it was hit by some soft object. So that Caesar memo, those witnesses. So witnesses from the spot and the witnesses from the faculty, they go together go on to form a chain. And the chain is that in the morning he has a visor, and in the evening the visor was not there, and the pieces of visor was found on the spot. And the doctor's opinion that she was hit by very thick object, blunt and thick object, and that is why her ribs were fractured. So helmet can be one such object. So is it not suggesting some logical connection chain that कि helmet से था मारा जा सकता था, ऐसा डॉक्टर का कहना है, क्योंकि ब्लड काफी क्लॉट कर गया था. अगर शार्प ऑब्जेक्ट से मारोगे तो ब्लड बाहर आएगा, और बॉडी में थोड़ा बहुत ब्लड आया था मेनली ब्लड अंदर की तरफ क्लॉटेड था. प्लस हेलमेट का सुबह वाइजर मिलना और शाम को नहीं मिलना. फिर उसका झूठ बोलना. पूछा गया कि हाथ में क्या हुआ है, उसने बोला था 3 दिन पहले गिर गया था, और 3 दिन पहले हेलमेट भी टूट गया था. तो फिर सुबह वाइजर क्यों था और शाम को क्यों नहीं है. प्लस डॉक्टर ने ओपिनियन दिया कि इसका जो हाथ का इंजरी है वो फ्रेश इंजरी है, प्रेजेंट इंजरी है. सो दीज टू थिंग्स टुगेदर, the fracture part here, the visor part here, then he told a lie about the fracture. What all that suggesting? That his subsequent conduct of telling a lie, it is trying to hide something. Plus other surrounding factors also. For example, DNA testing clearly established that he has committed rape upon the girl. अब DNA testing कैसे establish होगा? That is by the report of the doctors and the expert opinion, that is expert opinion. So by that report it was proved that it was his semen found on the her body, her private part. Then late entry, that why he gets late and why he is so much insisting and even threatening the peon. And the inspecting officer suggests that the Santosh Singh on the same bullet, Santosh Singh came from the bullet from her house on the same day after the incident, because the incident is before 5 p.m. उधर से ड्राइव किया और ILI तक पहुंचा, and it is quite possible in between to bandage the hand, fake bandage, and to reach to the college. So it is not impossible to reach from the spot of incident to the ILI, because in this case they want to create an alibi. So that alibi was not proved because of this possibility. So all these facts are suggesting chain of circumstantial evidences. उसके अलावा his presence of testimony on the spot was the presence on the spot was given by the neighbor, by the testimony of neighbor, who identified him and who declared that. Plus, the earlier complaint filed by the girl, it will constitute motive for killing her. Plus, the quarrels with her will constitute motive. Plus, the past conduct of always following her, that is the manifestation. And on that date, it was proved by the bodyguard that he was chasing her. अब ध्यान रखना, हर एक ये एविडेंस अपने आप में एक फैक्ट है. क्वारल इज ए फैक्ट, कंप्लेंट इज ए फैक्ट, वाइजर का पाया जाना नहीं पाया जाना, दैट इज अ फैक्ट, एंड एवरी सच फैक्ट इज प्रूव्ड बाय सम एविडेंस। फॉर एग्जाम्पल वेदर देयर वाज क्वारल बिटवीन देम और नॉट, वो प्रूव होगा एफआईआर की कॉपी से। द पर्सन हु सोन द quarrel, they will come into the court and give the testimony, plus the commissioner, he tries to reconcile, he will give the testimony into the court। कंप्लेंट की कॉपी लगा दो, उससे प्रूफ होगा that she had filed a complaint against him। the conduct of chasing, the bodyguard will call into the court and he will be examined and cross-examined, and it will get established through him that yes, he actually had seen the accused। So every such fact will be is to be established by some other evidences। So everything is a fact, and every fact is a relevant fact if we see in one or other section, and every such relevant fact is proved by some oral or documentary evidences, and once proved they all together becomes evidence for what? Fact in issue। So ये relevant fact आपस में मिलकर fact in issue के evidences हैं, लेकिन रेलिवेंट फैक्ट अपने आप में प्रूव तो होंगे नहीं, उनको प्रूव करने के लिए आपको ऑरल या डॉक्यूमेंट्री एविडेंस देना पड़ेगा। इफ वी सी इट डायग्रामेटिकली, देन फैक्ट्स इन इशू कैन बी प्रूव्ड बाय सम डायरेक्ट एविडेंसेस लाइक आई विटनेस, वीडियोग्राफी एक्सेट्रा, or it can be proved by some relevant facts which also called circumstantial evidences, and this relevant facts also has to be proved by oral or documentary evidences। So जो relevant facts हैं, अगर direct evidences नहीं है किसी fact in issue को prove करने के लिए, तो relevant facts और circumstantial evidences prove करेंगे किसको? fact in issue को। बट ये relevant facts और circumstantial evidences ये किसके द्वारा prove होंगे? थ्रू oral और documentary proofs। ओरल या डॉक्यूमेंट्री एविडेंसेस से ये रेलिवेंट फैक्ट और सर्कमस्टेंशियल एविडेंसेस प्रूफ होंगे। जब ये प्रूफ हो जाएंगे और इनकी चेन कंप्लीट हो जाएगी, तब ये मिलकर फैक्ट्स इन इशू को प्रूव करेंगे। अगर इनकी चेन कंप्लीट हो गई और कंप्लीटली प्रूव्ड हो गई तो। लेट्स सी इट अगेन। देयर इज फैक्ट इन इशू। हाउ कैन यू प्रूव अ फैक्ट इन इशू? either by the direct evidence, eyewitness, etc., video recording, or you have got certain relevant facts। Suppose there are several relevant facts: relevant fact 1, relevant fact 2, relevant fact 3, relevant fact 4, and so forth। And in the present example, one relevant fact is that he told a lie about the injury and of the helmet, and other relevant fact is that in morning it has the visor and in evening it does not have, and the visor piece is found on the spot। Then the third relevant fact is the motive. Fourth relevant fact is the conduct of chasing. Fifth relevant fact is that he was found present on the spot near the house by the neighbor, and so forth। So these are the various relevant facts, and why they are relevant? Because they fall under one or another section which establish the connection of that fact with the fact in issue। Similarly, he tried to create the false evidence of alibi by threatening the peon। All that is what? All that is his conduct, which falls under section 8. As per section 8, he got a connection. It got a connection with the fact in issue, and each of these relevant facts has to be duly proved। So for this relevant fact, there has to be a oral or a documentary evidence। So all the facts, relevant fact number 1, 2, 3, all these facts have some oral or documentary proof। They have to be proved by oral or documentary evidence। Suppose this is the fact in issue, and these are the other relevant facts 1, 2, 3, 4, 5, and these are to be proved by the oral or documentary evidences। D1 is the documentary evidences, O1, O2 is the oral evidence. Similarly for D3, or O3, D4, O4. So these are the evidences which go on to prove the relevant facts. So it may be documentary or oral, whatever evidence you got, you go on to prove this relevant facts. For example, the postmortem report, that is documentary evidence. FIR is documentary evidence, previous FIR. Then the peon came to the court to give the testimony that he has threatened me. That is a oral evidence. But the register maintained, that is a documentary evidence. So in that way, you have got several evidences. And for one relevant fact, you can give oral or documentary, both mix evidence also to prove that. So the evidences which are given to prove the relevant fact are called the oral or documentary evidences. Means these evidences are to be given to prove the relevant facts. And when these relevant facts are duly proved, they themselves become evidences. वो अपने आप में एक बार प्रूव होने के बाद अपने आप में एक एविडेंस बन जाती है रेलिवेंट फैक्ट. If the relevant facts duly proved, they in themselves become the evidences. Become the evidence for what? For the fact in issue. They themselves become the evidences for the fact in issue. And therefore you say that the fact in issue or the facts in issue need to be properly proved. Fact in issue or fact in issues need to be properly proved. And in order to prove them, either you have a direct evidence or you have a direct evidence plus relevant facts, or if you don't have the direct evidence, then the relevant facts. And these relevant facts, each of them has to be proved duly through the evidences, oral or documentary. And once these relevant facts are proved, then they will together go on to complete the chain of circumstantial evidences. And if once the chain of complete circumstantial evidences is completed, they will together go on to prove the fact in issue. तो इसीलिए सबसे पहले फैक्ट इन इशू फाइंड करो, फिर उसके बाद उस कॉन्टेक्स्ट में कौन कौन से फैक्ट्स रेलिवेंट हैं उनको पता करो, देन हर रेलिवेंट फैक्ट को प्रूव करो, फिर चेक करो जितने भी प्रूव्ड रेलिवेंट फैक्ट्स हैं वो मिलकर क्या प्रोसिक्यूशन की स्टोरी को कंप्लीट कर रहे हैं. Are they completing the chain of circumstantial evidences? If yes, then the fact in issue is ultimately completed. Proved. Completely proved. And that is what Evidence Act is about. So write down, facts in issue need to be proved by the party concerned, and for that purpose either there will be some direct evidence or there will be the other surrounding facts. All those facts which are found to be relevant have to be examined and have to be proved. Those relevant facts which are duly or properly, duly means properly, proved shall be taken into consideration, and if it is found that the various relevant facts together go on to complete the chain of circumstantial evidences, then it is said that it will be said that fact in issue have been proved. Each of these relevant facts has to be duly proved by oral or documentary evidences. और ये हर एक जो रेलिवेंट फैक्ट है ये ड्यूली प्रूव्ड होने चाहिए बाय ओरल और डॉक्यूमेंट्री एविडेंसेस से. द रेलिवेंट फैक्ट्स therefore become the evidences of the facts in issue, and therefore they are also called evidentiary facts or circumstantial evidences. अब कोई फैक्ट इन इशू है तो फैक्ट इन इशू में प्लूरल भी होगा, वेरियस फैक्ट्स इन इशू. सो उसमें से एक फैक्ट इन इशू को उठाते हैं हम. सो हमको क्या करना है, ये देखना है कि फैक्ट इन इशू, कोई फैक्ट इन इशू प्रूव हो रहा है या डिसप्रूव हो रहा है। प्रूव होगा तब भी उसके लिए एविडेंसेस देने पड़ेंगे, डिसप्रूव होगा तब भी उसके लिए एविडेंसेस चाहिए होंगे, या फिर लैक ऑफ एविडेंसेस की वजह से डिसप्रूव हो जाए, either way, but we are talking here about the proving of the fact in issue. So fact in issue को prove कैसे करते हैं हम? By several facts. अब in the beginning there are several facts. Fact 1, fact 2, fact 3, fact 4, fact 5. Here we are not using in beginning the word relevant. So out of these facts, fact 5, 6, so and so forth, out of these facts, only those facts will be used which are relevant, which are legally relevant. Facts तो 1000 हो सकते हैं। एक्यूज ने, फॉर एग्जाम्पल जो हमने एग्जाम्पल देखा, एक्यूज ने मर्डर वाले दिन क्या खाना खाया था, वो भी फैक्ट हो सकता है। संतोष सिंह ने कैंटीन में क्या खाया था, वो भी फैक्ट हो सकता है। संतोष सिंह ने घर पे क्या ब्रेकफास्ट किया था, वो भी फैक्ट हो सकता है। सो एंड सो फोर्थ। बट विल यू यूज ऑल दीज फैक्ट्स टू प्रूव द फैक्ट इन इशू? अब संतोष सिंह ने क्या घर पे खाया था, कैंटीन में क्या क्या खाया था, उससे कोई फर्क पड़ेगा? उससे हमारा क्या लेना देना? इस केस में हाउ दिस फैक्ट इज कनेक्टेड विद हिज ब्रेकफास्ट, जो ब्रेकफास्ट वाला फैक्ट है, हाउ इट इज कनेक्टेड टू फैक्ट इन इशू। अब कैंटीन में कुछ खाया था, उसका एक रिलेशन तो हो सकता है दैट ही गो ऑन दैट डे ही गो टू द कैंटीन, और जब वो गया था तो ये पॉसिबल है कि उधर के कैंटीन के जो मालिक है उसने देखा था कि दैट हेलमेट वाइजर है कि नहीं। तो जिससे वो प्रेजेंस पहले प्रूव हुई, और प्रेजेंस प्रूव हुई तो उसने उसकी टेस्टिमनी, जो कैंटीन वाले की टेस्टिमनी प्रूव हो गई। सो इट विल कॉरोबरेट द टेस्टिमनी ऑफ द कैंटीन ओनर। सो उस दिन कैंटीन में गया था वो, उसने समोसे खाए थे, so that was the sufficient time to observe by the owner of the canteen that there was visor on the helmet. So in that way it may be relevant but otherwise not. So each and every fact that surround the facts in issue may not be relevant. So first of all you have to identify the various sections of the Evidence Act as to which facts are relevant. Then you next have to identify that which facts are duly proved. So each of these relevant facts has to be proved, and those of them which have been proved, they will be used to prove the fact in issue. मान लो इसमें फैक्ट नंबर 1 रेलिवेंट है, फैक्ट नंबर 2 रेलिवेंट है, फैक्ट नंबर 3 रेलिवेंट नहीं है, फैक्ट नंबर 4 रेलिवेंट नहीं है। सो जो 3 और 4 फैक्ट नंबर है उसको तो आप प्रूव ही नहीं करोगे, क्योंकि ये रेलिवेंट नहीं है, तो उसको प्रूव करके क्या करोगे, क्योंकि वो तो एविडेंस में यूज होगा नहीं। एंड फैक्ट नंबर 5 मान लो रेलिवेंट है। सो व्हाट फैक्ट्स विल यू प्रूव इन द केस? यू हैव टू प्रूव द फैक्ट नंबर 1, 2 and 5 because they are relevant facts. So you have to give evidences for fact number 1, fact number 2 and fact number 5. So when the evidences is given, out of these evidences, suppose fact number 5 is not proved, duly proved. ऐसा पॉसिबल हो सकता है, फैक्ट तो है पर उस पर एविडेंसेस प्रॉपर नहीं है, सफिशिएंट एविडेंस नहीं है। सो फैक्ट रिलीवेंट जरूर है बट वो प्रूव ही ड्यूली प्रूव नहीं हो पाया। अब जैसे कैंटीन वाला आया टेस्टिमनी देने के लिए कि उसके हेलमेट में वाइजर था, अब अपोजिट पार्टी ने प्रूव कर दिया कि उस दिन वो छुट्टी पे था, तो उसका फैक्ट प्रूव नहीं हो पाया। सो इन दैट वे दिस फैक्ट वाज नॉट प्रूव्ड, even though it was relevant, but it is not duly proved. Now the question came, what facts you will take into the consideration in deciding the case? Fact number 3 and 4 no, because they are not relevant and moreover not proved. Then fact number 5 no, even though it is relevant, it cannot be duly proved. So it is only fact number 1 and 2 which are relevant and duly proved. They will be used to prove the fact in issue. अब इसके लिए आप 165 का फर्स्ट प्रोवाइजो देखो। provided that provided that the judgment must be based upon facts declared by this act to be relevant and duly proved. So ये जो अभी हमने पढ़ा है, the proviso is saying the same thing. Provided that the judgment must be based means what? Fact in issue must be proved only by the facts which are declared to be relevant and which have been duly proved. अब इन 5 फैक्ट में मैंने फैक्ट नंबर 3 और फैक्ट नंबर 4 मना कर दिया. Why? Because it is not relevant. And in the proviso it is written that judgment must be based only upon the relevant facts. So irrelevant facts will not be taken into the consideration. So fact number 3 and 4 are discarded. And out of relevant facts also, only those facts will decide the case which are found to be duly proved. And therefore, fact number 5 I rejected because fact number 5 was not duly proved. So what facts we are going to use? The fact number 1 and fact number 2. So what this proviso of section 165 declares is a general principle and a line of mandate upon the court that no matter what you do in the trial, but ultimately the judgment has to be based only upon relevant facts, and that too only those relevant facts which have been duly proved. So write it down. The first proviso of section 165 declares the principle that the court shall base the judgment upon only those facts which are relevant in the case as per the Evidence Act and which have been duly proved, properly proved. Thus, it is implicit that if a party seeks to prove a fact which is not relevant, the court shall not allow that evidence regarding that fact. The court shall not allow that evidence regarding that fact. And similarly, if the party wants the court to use a relevant fact to decide the case, then the court shall not use the fact unless it has been duly proved, properly proved. You see, this is what is called the admissibility of evidence and admissibility of fact. अब टॉपिक शिफ्ट हो रहा है आपका, रेलिवेंसी ऑफ फैक्ट हो चुका. अब ये जो लास्ट सेंटेंस है इससे एडमिसिबिलिटी में हम एंटर करेंगे. अब सपोज दिस इज द फैक्ट इन इशू which is to be proved. This is the example we are taking for explaining the admissibility of evidence and admissibility of facts. Suppose this is the fact in issue which has to be proved. Now the party says that I am going to give the evidence, oral or document. Party wants to give evidence to prove a particular fact. Party says that I want to prove that oral or documentary evidence to prove any of this particular fact. Now at this time, what will be the consideration of the court? The court will aware that I can decide the case only on the basis of the relevant fact which have been duly proved. Because court knows that कि किसी irrelevant fact को जब मैं यूज ही नहीं कर सकता तो उसको उस पर एविडेंस क्यों अलाउ करूं. Therefore, जब कोई पार्टी कहता है कि मुझे मान लो इधर फैक्ट नंबर 3 पर कोई एविडेंस देना है या 4 पर कोई एविडेंस देना है, तो कोर्ट इस चीज को जरूर एग्जामिन करेगा कि ये फैक्ट इस केस में रिलेवेंट है या नहीं है. अगर ये इस केस में फैक्ट ये रिलेवेंट नहीं पाया गया, देन इट इज ए रिलेवेंट फैक्ट एंड द कोर्ट विल नॉट अलाउ evidence for this fact. The court will not allow this evidence because it is generally wasting the time of the court. Because proving of a relevant fact that will take time, producing witnesses and getting examining, then cross-examine, that is not going to any use. So why should the court go for getting that fact proved and allowing the evidences to prove that fact unnecessarily? And therefore the court will disallow the evidence to prove that fact. So that evidence which is regarding an irrelevant fact is inadmissible in a suit or proceeding. सेंटेंस पे ध्यान दीजिएगा, कोर्ट आपको इररेलेवेंट फैक्ट पर एविडेंस नहीं देने देगा। क्यों? क्योंकि कोर्ट को 165 के प्रोवाइजो में कहा गया है दैट द जजमेंट शुड बी always based on relevant fact and that to be duly proved. And court is always aware if this party going to prove this irrelevant fact, then it is not going to any use, and therefore why should I allow the party to prove an irrelevant fact? And therefore if the party want to seek some evidence that I want to call Mr. X to prove the fact, then the court will ask him, for what purpose? What do you want to prove? Suppose he said that I want to prove fact number 3 or fact number 4. Then the court will ask him that first you will tell that how the fact number 3 or 4 is relevant to the case. And if it is not proved to be relevant, then the court will declare that the evidence of Mr. X is irrelevant, inadmissible. Evidence of Mr. X is inadmissible. ये एविडेंस अग्राह्य है, मतलब जिसको आप एडमिट नहीं कर सकते हो. सो दैट इज व्हाट कॉल्ड द इनएडमिसिबिलिटी ऑफ एविडेंस. सिमिलरली कोर्ट कहता है कि मुझे फैक्ट नंबर 2 प्रूव करने दो, तो कोर्ट पूछेगा ये कैसे रिलीवेंट होगा. कोई पार्टी कहती है कि मैं इसके ऊपर डॉक्यूमेंट देना चाहता हूँ और किसी का स्टेटमेंट कराना चाहता हूँ, तो कोर्ट पूछेगा ये कैसे रिलीवेंट होगा. अब पार्टी सेक्शन नंबर 6 से 55 तक कोई रेलिवेंसी प्रूव कर देती है फैक्ट नंबर 2 की. इफ इट इज रेलिवेंट देन दिस एविडेंस इज अलाउड. दैट इज व्हाट इज कॉल्ड एडमिसिबिलिटी ऑफ एविडेंस. ये ध्यान रखिएगा, आई एम नॉट सेइंग एडमिसिबिलिटी और इनएडमिसिबिलिटी ऑफ फैक्ट्स. आई एम सेइंग एडमिसिबिलिटी और इनएडमिसिबिलिटी ऑफ एविडेंस. ओरल और डॉक्यूमेंट्री, किसी पर डॉक्यूमेंट और ओरल टेस्टिमनी दे सकते हो कि नहीं, that is called the admissibility or inadmissibility of evidences. अब why is that approach taken by the court? Because section 165 proviso, first proviso, clearly mandate upon the court that the judgment shall be based only upon the facts which has been duly proved and which are relevant. So in that way you have to examine what evidences are allowed and what evidences are not allowed. So similarly अगर fact number 2 है, relevant है, इस पे court will allow the evidence. Fact number 5 है, if it is relevant, court find if it is relevant, the court may allow the evidence upon it. अब court allowed evidences for 3 facts. First, fact number 1, 2 and 5 to prove these 3 facts. So you will say that regarding the fact number 1, 2 and 5, the evidences are admissible. But regarding fact number 3 and 4, the evidences are not admissible. Because this fact 3 and 4 are irrelevant. तो इन पे inadmissible हैं evidences. Now, अब ये 3 facts हैं. Now we are talking about the admissibility of facts. अब तक तो हमने admissibility of evidences के बारे में देखा. Now about the admissibility of facts. ये जो 3 facts हैं, fact number 1, 2 and 5, इनमें से what facts are admissible to prove the fact in issue? Out of these 3 facts, what facts are admissible to prove the fact in issue? Those facts which are duly proved. अब suppose evidences were allowed upon these 3 facts, all these 3 facts, but party was unable to prove the fact number 5. एविडेंस अलाउ तो हो गए फैक्ट नंबर 1, 2 और 5 को प्रूव करने के लिए, बट पार्टी वाज अनेबल टू प्रूव द फैक्ट नंबर 5. द पार्टी कैन able to be prove only the fact number 1 and fact number 2. So which facts are admissible to prove the fact in issue? the only fact number 1 and the fact number 2. So when we talk about the admissibility of facts, then these are those relevant facts which are duly proved. They will be allowed to be used for proving the fact in issue. And when we are talking about the admissibility of evidence, so those evidences will be allowed to be proved, which are evidences upon the facts which are relevant. Only those evidences are allowed which are upon the facts which are relevant. So write it down, write this point. Admissibility of evidence means that those evidences will be allowed to be proved which are upon relevant facts. And thus, if any evidence is sought to be proved upon the irrelevant fact, such evidence is inadmissible. Similarly, admissibility admissibility of fact admissibility of fact means only those facts will be taken into consideration by court which are relevant and which have been duly proved. So this is the introduction about the admissibility of evidence and admissibility of facts. These are two things: admissibility of evidence and admissibility of facts. We would continue this into the next lecture. Thank you for watching this lecture.